Hello, everybody. My name is Alexis, and I am going to be talking about testamentary capacity today. And here we're going to get into this is a civil matter, so it's not anything in regards to criminal capacity. It's more on the civil side of things. And so what is testamentary capacity? So, testators have the ability to generally comprehend the nature and extent of their property, their relation to individuals who would claim to benefit from that property, and the effect of the will itself. So, there are some legal requirements when it comes to testamentary capacity. So, the testator must be of sound mind in order to prepare the will. So, these sometimes can have issues calling for clinical expertise, which would be due to the testator being subjected to possibly undue influence at the time of executing the will. And undue influence can be another individual's opportunity to exert the influence or the factual evidence of improper influence extended or attempted to do so at that time. Um, some of these legal requirements, the testator must know at the time of making the will that they are preparing the actual will. So that's the basis of that sound mind. They have to know and comprehend what's going on. Um, they also must know the nature and extent of their property. So they would need to know all the information necessary in regards to their property that they would be putting in the preparation of the will. Um, they must know the natural objects of their bounty and know the manner in which the wills they're making distribute their property. And sometimes there are some suspicious circumstances that come into play, which could be like the extent to which the donor was maybe in a weakened condition and could have been easily influenced. Or, the person who's trying to, do them in the wrong way, um, the extent of how much participation they had in the preparation or even the completion of the will. So sometimes people want to know whether it was done in secrecy or haste, or whether the testator themselves had maybe a negative attitude towards the person who was trying to do the wrongdoing when it comes to preparing the will. So we're going to get into also some clinical evaluation of the testamentary. And the testamentary capacity is different than most capacities because in most cases, the subject is deceased. So, although areas of the inquiry are similar, the source of information is the key difference. So, there are a couple of things that come into play when clinical evaluation is involved. And the main thing that they would like to recommend is that evaluations are video recorded. So this can kind of let us know, like, for example, if maybe someone's saying that, oh, this will was prepared because my grandfather was mentally ill at the time, and then they feel that things weren't executed properly because of his mental illness. Um, that testamentary will basically the evaluation needs to be recorded because it will show how he was physically at that time, physically and mentally. Was he answering all the questions correctly, so on and so forth. um, the knowledge of making the will is important because when a testator is available for interview, the examiner should ask about his or her understanding of the purpose of the will, if any previous wills exist, and why they are preparing the will. So asking why can reveal any delusional motives that may be present. The knowledge of nature and extent of property. If a testator is alive, necessary questions would be about occupation, salary, living situations, personal possessions, intangibles, anything that you would put in your will. Examiner questioning should always be open-ended in order for testers to respond in their own words. And if a testator is deceased, the examiner would have to base their evaluation on the objective information in the will if there's one that's already been made. And so the main thing they want to know with that is, does the disposition match the estate, as the book says, our textbook, or does the will attempt to bequeath items that they don't even possess? Um, and then, of course, knowledge of natural objects of bounty. This is where forensic examiners are most useful because they can make certain that the testator's values and preferences are correct to establish their intent for even making the will. If a testator has ill will towards an individual, it does not render them incapable of executing the will. So just because they may be unhappy with someone at that given time, it doesn't necessarily mean that they're not capable of creating their will or executing what's in the will. And an examiner can ask about a testator's view of his or her relations with somebody, because if a testator is putting someone in the will, then the examiner would like to know why they put them in the will. And it kind of gets more difficult when a testator is deceased because the will may have excluded people who feel that they should have been included. So a clinician will just attempt to reconstruct those relationships based on other sources. Knowledge of the manner in which property is disposed. If the testator is alive, the clinician should focus on general questions about the disposition of property made, which will reveal the facts of why the testator made that decision based on that property. Here are a couple of examples that you guys can look into. The one on the left, it says an introduction to testamentary capacity. This is just extra information, basically explaining more in detail what testamentary capacity is and giving you some examples of what that looks like. And on the right side here is an actual article of a testamentary that occurred where a family pension was supposed to be um, executed based on a will, and the husband couldn't exclude his wife and children from that, but he wanted to do so because they were getting divorced. Um, so if you want to read on that, that's in there. The references are available to you here. And discussion question: do you believe that testamentary evaluations are necessary if a testator was under the influence of a substance at the time they prepared their will? Why? And give an example.